Welcome back to Canadian Justice, where we're discussing prosecutorial independence and allegations that the Office of Premier Danielle Smith had interfered in the discretion of prosecutors regarding prosecutions for COVID-related offenses. Now, Professor Williams, can you explain to our viewers what exactly is this concept of prosecutorial independence and discretion and why it is important for our justice system?
Well, it amounts to the rule of law, that everybody be treated equally under the law, and that it not matter if you are a friend or foe of the government, you're going to be treated equally under the law. So it shouldn't matter if the government likes you or your cause and is willing to sort of put its thumb on the scale in your favor. And it shouldn't matter if let's say you've been challenging the government or asking questions about the government, that shouldn't matter either. You ought to be treated under the law based on the facts of the case before you. And because of these public statements that already are seen as putting the thumb on the scale, and now these allegations, there's been direct pressure applied, the question now becomes whether a fair hearing can be provided for the cases that are before the courts.
Stephen, anything you want to add to that to give our viewers a sense of the importance of this principle in our justice system?
Well, yeah, it turns out that this is a very complex area of the law and of policy, and there are somewhat differing views on the precise nature of the relationship between the executive arm of government, including cabinet and the premier or prime minister, and the attorney general, who is both a member of cabinet, but in addition is also supposed to be an independent overseer of the prosecutorial function within the province, or in the case of the federal government, the federal jurisdiction. And there's a debate, I think, and a bit of a lack of clarity in the law as to what counts as improper influence or consultation as between sort of the politically responsible, the democratically responsible executive branch of government and the independent or quasi-independent role of the attorney general. And so it's generally agreed that some degree of consultation and communication on policy grounds and thinking about what are the effects of either proceeding or not proceeding with a given prosecution or a given type of prosecution is perfectly legitimate. And that's an aspect of our democratic system that ensures political accountability ultimately to the electorate. But of course, a line can be crossed where private partisan advantage can be sought by government, and that is clearly improper. And if that's what happened either in the SNC-Lavalin case or in the case in Alberta, then it would be a very different matter.
Now, Professor Penney, I know that it is possible for governments to say, we want amnesty for this particular type of offense. So cannabis is a great example. There have been big movements to provide cannabis amnesty for people who were convicted of cannabis-related charges prior to the legalization of cannabis. So hypothetically, if the premier wanted to do something like that related to COVID instead of cannabis, how much authority would she have to create a system for that? Now, I'm not saying that randomly calling Crown attorneys and telling them not to prosecute offenses is an appropriate system. I think we can probably all agree that's not appropriate. But what would be within her power to do?
Well, first of all, she would ultimately only have the power, or the government or the legislature of Alberta would only have the power to potentially provide some kind of amnesty with respect to provincial offenses. So, because of the federal division of powers, they would have no authority over criminal code offenses or other federal offenses. But yes, in theory, any government, usually acting through the legislature, through legislation or at least regulation, can provide some kind of amnesty, whether you want to call it a pardon or remission of sentence. In the federal context, you can get pardons with respect to your criminal record, both generally and in the specific case of cannabis possession. But it would require some transparent and democratically accountable process, ideally through legislation, where a certain individual or body would be empowered either on a sort of categorical basis or on a case-by-case basis to grant appropriate amnesty. And that can follow from a particular government's policy concerns. So, for example, I don't think there's anything wrong with the government saying, we don't think the full application of this law, which was in effect at the time, and where offenses may have been committed under this law, we don't think it's in the public interest, generally speaking, to prosecute these offenses or to impose punishments for these offenses. If that's done in a democratically accountable way that does not speak to partisan considerations, it's done on a policy basis and it's done transparently. So then the electorate, the voters can decide whether they agree or disagree with that policy. But something like that could be done.
Right. A lot of nuance here that we're not always getting from the general conversations. We got to go to break, but we'll be back.